Okay. Thank you. And before I call the case, just let me note that the panel has been reconfigured and that Justice Joseph Ditkoff is here replacing Justice Robert Toon.
That's
just
about a drop of a foot in height.
Just this one case, and the case number is 2023-0455, Newton Police Superior Officers Association versus the City of Newton and another. All right, Counselor. Good morning.
Good morning, Your Honors. May it please the Court, Jacqueline Zawada for the appellant, the City of Newton. I would like to begin this morning by elaborating on the second issue in the city's brief, and that is that this board's decision must be reversed because their conclusion that the transfer was an adverse action is not based on the substantial evidence. And I'd like to
ask you to lean a little closer to the microphone, if you would, so I can hear you a little bit better. Thank you very much. Just lean a little bit closer, and it'll pick up your voice more accurately. Thank you.
Thank you. I will do that. I would like to immediately draw the Court's attention to the objective evidence on this record. Again, this was an appeal to CERB, and CERB was bound to consider the record before it. And so I'd like to immediately draw the Court's attention to the fact that in this case, the sergeant was transferred from the Traffic Bureau to the Patrol Bureau, and upon transfer received a significant pay increase of nearly $6,000, 8% of his salary. And so I submit to this Court that the board did not consider that evidence. They relied solely upon the subjective testimony of the sergeant, who stated that he preferred, quote unquote, his prior schedule because it was, quote unquote, beneficial for his family. And that was the whole of the evidence that they relied upon, to the exclusion of, again, this objective evidence of a pay increase. And so there was no dispute as to that fact. There was evidence on the record, and insofar as payroll records.
Doesn't that presume that a pay increase automatically is something more tangible and more important than one's work schedule? I mean, work balance schedule seems to me something that would be on the same par as a increase in pay?
Well, and so actually, Your Honor, I would like to sort of parse that out because I would like to draw the Court's attention to the Yee decision. The SJC in Yee states flat out that additional compensation is an objective indicator of desirability. And so we see here that in the Yee court and certainly other decisions that preceded it, additional compensation is objective evidence which courts can and do rely on to determine that there's been an adverse action.
Sure, but a change from a daytime schedule to an irregular nighttime schedule seems to me an objective measure as well.
Well, Your Honor, actually, I think that there's cases
It was undisputed that the schedule went from a regular 5-day-a-week daytime schedule to a nighttime schedule that changed periodically. So it wasn't even the same nighttime schedule all the time. It was a changing nighttime schedule. That seems to me like objective fact.
Well, certainly the schedule change was part of this transfer, obviously, from one bureau to another. However, what came into the evidence on this record was certainly that this sergeant, he personally preferred his prior schedule. However, if we look at the remainder of the record, we see that first and foremost, the board was bound to consider this from a reasonable person in the employee's shoes. So it's not a person such as myself who works 9 to 5, for example. It's a police officer. It's a reasonable police officer's shoes. And so we can see that firstly, they should have considered that. Police officers work 24/7, 7 days a week. There was testimony on this record from various officers that they work all hours of the day, every day of the week, 365 days of the year. And moreover, there was testimony on this record that basically proved to show that this sergeant's subjective opinion on not preferring the schedule was not shared among his other officers. Other officers testified that, in fact, one in particular testified that he was forced to work days because no other officers wanted to work days as well. And so, in other words, this was a sort of subjective opinion as far as which schedule was better or worse. Officers can disagree. And so I like to draw the Court's attention to the fact that this is...
If there's so many officers who want to work days, why don't you... how many officers want to work nights? Why don't you let one of them switch with this sergeant?
Well, I mean, certainly, and that sort of gets into this particular sergeant's position. He was transferred out of the Traffic Bureau and into the Patrol Bureau following numerous concerns, most clearly the issue with his subordinate. He had engaged in a verbal altercation and admittedly made her cry. She never returned to work. They were not on speaking terms. There is no dispute in the record that this particular officer needed to be transferred out into another bureau and needed to be separated from that person. So I think, to your question, Your Honor, I think this was a particular need for this sergeant to be transferred to a different position. But again, it was not adverse to him. An adverse action must be objectively and materially disadvantageous to the employee. And so in this case, again, the board completely disregards the significant pay increase, which again, the Yee Court concludes that additional compensation is an objective indicator of desirability. In other words, they used the additional compensation evidence in that case to conclude that there had been an adverse action. And so that sergeant had been denied a transfer, which he alleged and showed through evidence that would have been an adverse action, and the court agreed. So by the same logic here, where we have our sergeant who was transferred out and received more money as a result of that transfer directly, there is objective evidence that he was at an advantage. He received, in other words, a benefit, which the board fails to contend with. I do want to draw some attention to the Bayer case, which is cited by the Yee Court. This is a Second Circuit decision, a U.S. Court of Appeals decision, but I think it's helpful because it sort of draws out these distinctions between objective evidence, such as these sort of changes, additional compensation or changes in grade or salary, and compares them to subjective feelings of disappointment, feelings of disillusionment.
There's a lot of scientific data on the negative effects on both cognitive and sleep of working night shifts. What are we supposed to do about that? That's objective data.
Well, it could be. I don't believe that was shown through this record.
Right, so
and certainly what the board was obligated to do was consider the record before it.
Sure, but can't the board use its own expertise in evaluating whether the change to a night shift is objectively adverse?
Well, again, when applying the substantial evidence standard, the board was required to consider the substantial evidence, which needs to include the evidence on the record that fairly detracts from that conclusion.
Right, so it was switched to nighttime on an irregular schedule from daytime on a steady schedule. Mm-hmm. I think we understand your argument. I'd like you to switch to your first argument, if you would.
Okay, certainly. If I may, before I do, Your Honor, I only want to point out one case which is cited in the board's brief, which I'd like to offer a nuance to, and that is the Ginger case. The board relies only on Ginger versus District of Columbia in, again, concluding or support for its conclusion that the transfer was adverse. And this is sort of in line with that conclusion that the change in schedule alone was enough to show this was adverse. However, that is not what Ginger stands for. If we look at the court's decisions, it was the District Court and the U.S. Court of Appeals. What was vital to their conclusion, actually, was the fact that in those cases, in Ginger, it was a group of police officers who were moved from straight midnight shifts to rotating shifts. And so in other words, they went from straight overnight shifts to some shifts which were not. The courts concluded there was an adverse action, but not because of the change in schedules, because they lost their night differential, which ironically on this fact is precisely what this sergeant gained as a result of his transfer. So again, I think that case, again, certainly does not stand for, in my opinion, the premise that the board's putting forth, but actually buttresses what the city is trying to establish, which is that these objective indicators of desirability, such as a change in pay or other evidence showing changes to the terms and conditions of employment, as opposed to subjective
I think we understand your point about what you think is the most objective and, in your view, compelling. But Justice Wolohojian wanted you to answer some other questions.
Certainly. So moving to the first issue in the case, that would be concerning the board's decision requiring reversal because firstly, the union did not show that this sergeant had a generally good work record, and moreover, the board did not act in accordance with the law in failing to require that of the union. And so I first would like to point out that the board, in its brief, admits that it never varies the prima facie case of a charging party alleging retaliation under 150E. We know off the bat that this is not in accordance with the law. Smith College, cited in the city's decision, makes clear the prima facie case, quote, necessarily varies in accordance with job involved and the decision involved. So off the bat, we know that the board has ultimately admitted they don't do that. They don't vary the prima facie
All right,
case.
the prima facie case, I see the statement that it may vary on the situation. But the situation we've got here is a claim of retaliation for union activity, correct?
Yes.
Okay. The analogy, I think, is under, ultimately, this burden-shifting case came from the McDonnell-Douglas line of cases, correct?
Correct.
Which we've then also incorporated into Chapter 151B, correct?
Correct.
Right. 151B has both claims for discrimination and claims for retaliation, correct?
That's correct.
And the claim, this would not be, the kind of claim here would be akin to the 151B retaliation claims, right?
Yes. I would
Not,
agree.
it's really not analogous to the 151B discrimination claims.
I don't know that Trustees DeForb's library goes that far, Your Honor. I would say that case actually states that, discrimination generally under Title VII, under the federal law, and then under 151B under the state law, and 150E retaliation are all sort of subject to the same analysis or
But
analogous analyses.
depending on the facts. And the facts are that in 151B cases, the elements of a prima facie case for discrimination are different than the elements for a prima facie case for retaliation under 151B.
Yes.
So why isn't that what trustees of, is it Forbes, is referring to? That whether the elements of the prima facie case will depend on whether it's purely a retaliation case or maybe a retaliation and something else case.
Well,
And I guess what I'm really getting at here
yes.
is that I think the closest analogy are the retaliation cases under 151B. And those cases uniformly do not require the employee to prove the sufficiency of his or her work performance. And so I'm wondering why we would add that as a requirement under 150E.
Well, Your Honor, again, and just to be clear, the city's not proposing that in every case a generally good work record must be shown, but certainly it can and really should have been required here. And because of, firstly, the footnote in Trustees of Forbes Library gives us an example that a generally good work record might be included in the prima facie case.
It didn't say it would be, it said it might be.
It did. That's correct, absolutely. But then the year later in Southern Worcester County, the SJC found in its finding, in its holding, that those plaintiffs, a group of teachers, met their prima facie case in part because they showed they had a generally good work record. And furthermore, thereafter, the appeals court even went a step further and noted that a generally good work record is ordinarily being their word, to be included as part of the prima facie case.
Counselor, what does it mean to have a generally good work record?
And so I think, Your Honor, that it's important to point out that this speaks to, well, firstly, I think the performance of that employee in the course of their work.
I know
right?
it
And so
goes to performance, but what does it mean to get to the level of generally good?
Generally good. Well, I mean, I think in this case, the clearest way to illustrate that is to look at the record itself and.
Okay, well, if I look at the record himself, he never gets disciplined in any way that requires a suspension or transfer or anything. All he gets is a reprimand, which I think would seem to be generally good enough to work in the traffic bureau.
Well, and Your Honor, I think it's important, though, that the requirement is not a disciplinary record or a lack thereof, a lack of a disciplinary record. It's a generally good work record. So it's actually, I think, fairly generous. It's a somewhat lower bar than a lack of a disciplinary record. I think it implies that certainly there could be some discipline and still be able to prove a generally good work record.
But he doesn't even have discipline. So how does he not have a generally good work record for the context of running traffic events?
So absolutely. So I think in this case, again, it goes back to firstly, the incident that immediately preceded the transfer, which was this verbal altercation with his subordinate, in which he admittedly yelled at her, quote unquote, made her cry, and they were not.
But that wasn't enough to give him any discipline other than a reprimand.
And that's correct, but that's the point, Your Honor, is that I think that on this record, it's not insofar that this transfer was disciplinary in nature, but clearly these parties needed to be separated based on these facts. It's apparent. He admitted they were not able to speak to each other. He was using another officer to communicate and check in with the woman he'd yelled at. And so there's that, as well as the history of...
But that doesn't go to generally good work record. That goes to your failure to provide any reason why you made the transfer. I mean, obviously, if you had had McDonald testify, oh, I transferred him because I had to separate these two, you would have won in the board, but you didn't do that. But why does that go to, why does there being an employee that you have a conflict with mean you don't have a generally good work record?
I'm sorry, could you repeat that?
Why does having a other employee that you have a conflict with mean you don't have a generally good work record?
Well, I think that certainly reflects, again, his ability to work effectively in that role, to effectively supervise. This was somebody he supervised. And it's also taken into context with the other issues that are made plain on this record. His admitted failure to supervise, or at least his admitted knowledge of problems among his supervisees, and his determination that he would not take any action on it. His insubordination relative to orders to not take certain actions relative to pay details. And frankly, his testimony about his own subordinates. I think that all of the evidence on this record, which came from the sergeant in large part, shows that things were not going well for him in the traffic bureau. He did not have a generally good work record such that he would have made out a prima facie case. And so,
It seems to me that really the nub of this argument is whether the employee's performance gets parked under prong one, the prima facie case, or step two, which is when the burden shifts to the city. That's what this is really all about, correct? I mean, it's not that you're not going to be able to put that evidence in at some point. It just depends on whether it's required of the employee or whether it's something that the employer brings forward. My question for you is, when the claim is purely one of retaliation for engaging in protected activity, why, as a matter of policy, would we put it in prong one? Because, right, you'd be in essence saying that employees who are not adequately performing can be fired in retaliation for engaging in protected activity.
well, Your Honor, I think that it goes to the intent of the prima facie case, which I do discuss in the city's brief. I cite to the Blair case, which in turn the SJC cited.
But the Blair is a discrimination case, not a retaliation claim.
But I think that in terms of the prima facie case and based on Board of Trustees of Forbes Library,
right,
we can see that there is analogies
That's why I took you back to 151B, because Forbes is relying on the 151B cases, but it's relying on the discrimination cases, not the retaliation cases.
Your Honor, I would submit that Forbes is proposing that under 150E, the same burden shifting is followed. The same burden shifting that's happening under the federal law and the state law for discrimination for 151B and Title VII is also to be followed under 150E. And so I think it is, analogous and therefore important to consider that the intent of those decisions should mirror the intent here, which is that, again, the prima facie case, the purpose of it is to eliminate the most common non-discriminatory reasons for the action. And so I think that in this case, the board's determination that it would not look at the generally good work record therefore meant that they were not looking at whether there was a common non-discriminatory reason for the action. In this case, there's a whole record worth of poor performance that preceded this transfer. And so
I'm good.
Thank you for going over and answering our questions. We appreciate it, but
Thank you, Your
now you
Honor.
can rest on your brief. Thank you.
thank you, Your Honors.
All right. So with respect to the next argument, we have the attorneys splitting their time 10 minutes and 5 minutes. Is that correct?
That's correct, Your Honor.
Okay. Fine. Thank you.
Lon Canty on behalf of the Commonwealth Employment Relations Board. May it please the court. I'll address the last issue that my sister counsel addressed, the prima facie case. And I want to address a point that she made about how the prima facie case can change. I think in that case, that was referring to the prima facie case may change depending on which type of claim it is, whether it's a retaliation claim or a sex discrimination claim or a race discrimination claim. It wasn't referring to the same type of claim, which is here is a retaliation claim under 10A3. And that prima facie case must remain consistent throughout, or else litigants would not know what to prove before us. And the board and the court has consistently affirmed the Labor Relations Commission, the predecessor to the board's prima facie case, over and over again. There have admittedly have been references to a generally good work record, like in the Southern Vocational School case, so Southern Vocational School of Worcester case. The court said in passing, okay, these teachers proved they had a generally good work record. But that, again, was in passing.
Every published case that's discussed what the prima facie case has in the context of an appeal from the Labor Relations Commission or SERB says generally good work record. And I mean, you've established by citing a bunch of SERB cases that SERB is not listening to that at all, and even provided a good reason for that. But it seems to me that there isn't a single published case that discusses what the prima facie test is and doesn't have generally good work record in it.
Well, respectfully, Your Honor, I disagree. In that same case...
What is the published case that doesn't say, that describes what the prima facie case is and doesn't say generally good work record?
So in that same case, the court stated that the Labor Relations Commission utilized the same prima facie case that we used here and approved of the Labor Relations Commission's standard. And then it went through the first prong that the employee engaged in concerted protected activity, second prong that the employer knew of the protected concerted activity, and cited that exact standard that we continue to use.
But the answer to Judge Ditkoff's question is what? Judge Ditkoff asked you for a case name.
That's the Southern
Okay, but that case says each of the teachers established a prima facie case by showing he had a generally good work record. So that doesn't give me an example of a case discussing prima facie case that doesn't require a generally good work record.
I believe following that sentence, the court did cite the prima facie case that the board relied on. I may take a moment. I believe it is in that case later on that the court does cite the prima facie case that the board relied on and approves of it. And there are cases as well. I believe it was the Babcock decision versus Labor
Babcock in
Relations
footnote
Commission.
2 might include proof that an employee had a generally good work record.
I'm sorry, that it was the Board of Selectmen of Natick decision that did not address any explicit
Right,
standard.
that case didn't say what the prima facie case was at all.
That's correct.
I understand there are cases that don't say what the prima facie case is, but that doesn't establish that it doesn't involve a generally good work record.
Correct. So I think you're correct, except for the Southern Worcester case that I think the court explicitly approves of the prima facie case and that the board relies on in that case. Later on, in a separate paragraph. Admittedly, it is confusing because in some parts the court says we approve of the labor relations standard and then references the generally good work record that the board never used in a later part of the decision.
All right, let's assume that we were, I'm not asking you to concede this, let's assume that we were to conclude that the board used the wrong legal standard on the prima facie case. what, in your view, would be the relief here?
I think it would have to be a remand for the board to consider that factor. Because
Okay.
the board did not consider it.
I appreciate your frankness on that. I have a different question for you, if it's okay to move on to a different topic.
Yes, Chairman.
I'm puzzled, and I need some education here from you, as to the relationship between fact-finding by the hearing examiner, because the hearing examiner, correct me if my understanding of any of this process is wrong. My understanding is that the evidence came in before a hearing officer, and then there's an appeal taken to SERB. SERB doesn't take evidence again.
That's
It's
correct.
working off the record that was developed in front of the hearing officer. If the hearing officer makes credibility determinations or other findings of fact, is SERB just doing that de novo off a cold record, or does SERB, I'm trying to figure out what happens there.
So if there is a credibility determination, so there are conflicting testimony between two witnesses, and the hearing officer makes a determination on that, the board gives that determination deference, and it does not review it de novo.
Okay, so if the hearing examiner here finds that, if credits the city's witnesses as to the reason why, their motivation for the transfer, that the motivation was not retaliation, but believes the witnesses' testimony that they had a non-retaliatory reason for transferring the employee. How does SERB undo that?
Well, the board can look at the findings and conclusions from the facts
Yeah.
and overturn those conclusions, so.
The conclusions, but here it seems to me that what SERB did is, and again, correct me, because I'm not sure I understand the procedure fully. It seems to me that SERB essentially was saying, look, if you had contemporaneously documented the reason for the transfer to the night shift in the patrol unit, you would have been okay, but you didn't contemporaneously document that. And
I'm
yet the
sorry.
hearing officer heard the explanation from live witnesses and said, I believe it. I believe that's the reason. It was the, not retaliation for union activity, but these other things. How is that possible when, do you see what I'm saying? Like, that's just not like an appellate type of function.
If it happened the way you described, I would agree. It would have been difficult for the board to overturn it. But this wasn't a matter of whether or not, or what the hearing officer believed from the witnesses. It was what evidence did the city provide from the person who made the decision within the city. So the city relied on Lieutenant McMains, who did not testify at all about the transfer. He never said, I know it was because of all of this alleged misconduct or the incident with the parking control officer. He never said, I had a conversation with the chief who made the decision. The only testimony we have, the only evidence we have, and it's simply a burden of producing the evidence on behalf of the employer, is that the Sergeant Babcock testified that he had a conversation with the chief and asked for a reason, and the chief said, I'm the chief, I can do it. It's not a matter, if the chief came on the stand.
Which is true, right? The chief can transfer police officers from one shift to another, from one unit to another. The only thing is that the officer the chief can't do it for a impermissible reason, a retaliatory reason.
That's right. I think there is some language about that permits that in the collective bargaining agreement. Certainly, it wasn't an argument that the union made.
Right. So, I mean, the chief can do this. So the fact that the chief didn't have any other explanation other than that he can do it, how can you, do you see what I'm saying? Why isn't it still a matter of factual inference for the first hearing examiner?
Because it's a burden of producing the evidence, and there was no evidence for the hearing officer to rely on. This is very similar to the School Committee of Boston case, where the court affirmed the board's decision. And in that case, the employer said it was because of budgetary constraints that these custodians were laid off. They showed that there were these budgetary constraints. There's plenty of evidence of that. What they failed to show is that who the decision maker was, and when that decision was made, and whether the budgetary constraints played a factor in the layoffs. There was no evidence whatsoever that demonstrated that was the reason why there was a layoff. There was a legitimate reason.
So because the stage 2 burden is ordinarily very low, right? It's just a burden of production. And they did produce evidence of problems with this particular employee. Why are you saying that the city did not meet the stage 2 burden, or are you saying that it all falls apart later somehow when the trier of fact is going to evaluate the city's proffered reason against the employer's evidence?
Yes, it falls apart at the stage 2 burden, where the city just has to provide evidence. It's not a burden of persuasion, just the evidence.
It's just a burden of production.
Right, that's
Right, and they
correct.
do have the conflict, the fight from the month before.
They have that piece, but they don't have the second part, which is that it was the actual reason for the transfer. They don't have any evidence to support that.
Well, they have timing.
Well, Sergeant Babcock received a written warning for it, and then a month later, he was transferred for no reason, so without any explanation. So I'm not sure the timing is in their favor.
See, that seems to me more an issue of balancing the evidence, evaluating the evidence, as opposed to saying they failed to meet their burden of production.
Well, the court and the trustees of Forbes Library said that the board can rely on just the prima facie case if the city does not meet its burden of producing this evidence. And that's what the board did here, relied on the prima facie case because the city failed to produce the actual
And so
reason.
but here, so I guess it all comes back to if they use the wrong legal standard for the prima facie case, then I don't know where that leaves us. It doesn't leave the board any place good.
That is the first threshold, and we believe that Sergeant Babcock met that threshold, and then the city failed to meet its second burden.
And then so it would be remanded, and SERB can or cannot take more evidence. If we were to remand, does it get remanded down to the hearing officer?
I'm not sure, to be honest, Your Honor.
Okay.
Thank you.
I have some sort of things that are baffling me, that are not raised or preserved, so they don't go to the result, but I've got the chief counsel in front of me, so, and if you don't have an answer, that's fine, but I just thought I would take advantage of that, if you don't mind.
No, sure.
I mean, the first thing that kind of confused me is this is a 10A3 case, and that's discrimination in regard to any term or condition of employment to encourage or discourage membership in any employee organization. And it didn't seem to me, I didn't understand how that's even in play here. They're obviously not trying to discourage him from being a member of the union. It's a closed shop. So how does that get us to what happened here? And again, not raised, so it's not, it's not before us, but I just don't understand.
Sure. The board has interpreted that provision to mean discrimination in terms of any concerted protected activity. So not just when, they're trying to organize or when they're in a union membership. So the board has consistently, and I think the court has applied it outside of the realm of organizing as well, to protect employees who are engaged in concerted activity.
It's really helpful. The other thing that was kind of confusing me is there's a number of opinions, including one I wrote, that says that assignments like this by a chief are not subject to collective bargaining, cannot be ordered by an arbitrator in a collective bargaining process. And so it seems strange to me, again, not raised, not before us, but it seems strange to me that SERB would have the ability to order public safety assignments when even a collective bargaining agreement or a collective bargaining arbitrator can't. Is there something, I'm missing some case law on that I haven't seen?
There is case law on that, and unfortunately, I don't have it off the top of my head, but perhaps my brother counsel, I know he recently handled a case with these similar types of issues that he may have.
Was part of the relief here, I have to look back at the SERB decision, but did SERB order that the employee be returned to the original traffic assignment?
Yes, Your Honor.
I mean, again, it's not really before us, but if anyone could give me a case on that, I'd love to see it, just for my own edification.
Yes, certainly we can provide it in a letter after. Thank you.
Other questions? Thank you for answering all of our questions, including Justice Ifkoff's additional ones. It's appreciated.
Thank you.
You can rest on your brief, and now we will hear from Attorney Shapiro.
Thank you, Your Honor. My name is Alan Shapiro. May it please the court. I represent the union in this case, which is an intervener. Maybe I should address Justice Ditkoff's question. The chief has authority to assign people wherever they want, but they can't do it when they're discriminating against somebody. They can't put somebody, we had a case years and years ago where a police officer, the chief was mad at him because of some union thing, and he assigned him on the midnight shift to check parking meters.
Well, so I don't want to absorb your time on an issue that isn't in the case, but a chief can assign people contrary to a collective bargaining agreement.
Well, it isn't necessarily contrary to a collective bargaining agreement.
But even if a collective bargaining agreement says you can't assign people, that doesn't mean anything. The chief gets to do that. So what says that the chief can't do that? What you just said, is there a case?
The chief can assign people in his managerial function as the chief of police. What he can't do is assign people when he's doing it for discriminatory reasons, whether it's for their union activity, whether it's for their gender, whether it's for their age, whether it's for their nationality.
I think we have to be careful to distinguish between discriminatory reasons and retaliatory reasons. This is a case of retaliation, correct?
Okay, yeah.
This is not about, this was not presented, and it doesn't look to me like it's a discrimination case. It's a retaliation case based on protected activity. So I hear you saying that, yes, of course the chief can assign people anywhere he wants, except he can't do that for an unlawful reason, and in this case, the unlawful reason would be retaliation.
Correct. Correct, Your Honor. And that would be true for any form of discrimination. Just because the chief has the power to do it doesn't mean that he could exercise or she could exercise that in a way that is retaliating against somebody for engaging in this case, union activity.
That may be so, but a collective bargaining arbitrator couldn't order any kind of relief as to assignments, so why can SERB?
Because SERB's function, part of its function, is to redress claims of discrimination. And in this case, or retaliation for protected activity. And its job is to make whole, as a remedy, the discriminatee, who in this case is Sergeant Babcock. It's not a question of a collective bargaining agreement. It's a question of the power of the agency to address claims of discrimination under Section 10A3. It's different than an arbitrator. I agree. And is it the Natick case that you are referring to? I'm not.
City of Framingham. Town of Framingham.
Yeah, I'm sorry.
Was the one I wrote, but it was based on an SJC case, City of Boston versus Boston Police Superior Officers Federation.
Yes.
Can you help me with my questions about the relationship between the findings of fact made by the hearing officer and what weight or deference SERB is to give those? Because, we have about 1 million cases that say motivation is a question of fact. And it seems to me this whole case turns on motivation. And so if the hearing examiner has found motivation in one way, how does that get evaluated at the level of SERB?
Your Honor, respectfully, I don't think motivation is really the question here. I think the issue is part of the burden of an employer when an employee is made out a prima facie case is to come forward with a non-discriminatory reason or reasons for why it took the action it did, and to show that those were the actual reasons. Here, it's a legal principle. The city showed some things that where Sergeant Babcock was criticized, there was a reprimand that he couldn't appeal under the collective bargaining agreement or under civil service. And so and the hearing officer culled from the record and essentially said, well, this must be why they did it, why they transferred him. But nobody from Newton ever came forward in any way.
That's what an inference is, right? That's what an inference is.
I don't think an inference can be drawn, Your Honor. I think in this case there was also an allegation that Sergeant Babcock should have gotten another specialty job that he applied for. And the hearing officer and the SERB accepted as a reason a letter from the police chief explaining why he appointed who he did. So it doesn't take much, but we have nothing here.
What would have happened if McDonald had passed away or had a debilitating stroke before the hearing? Is that a situation where the employee just always wins because the city has no way of establishing the actual reasons?
I think that's a great question, Your Honor.
I'm concerned about, I know this is this case, but it could be the next case.
Right. I mean, if that assumes the chief never talked to anybody about what he was doing. Never. We had Lieutenant McMains, who is the executive officer and like the right-hand person of the chief, who actually wrote up the whole thing about the issue with Sergeant Babcock and the parking officer. He didn't test it. I mean, presumably there would have been some discussion between him and the chief over what should happen to Babcock. He offered no testimony on that.
So if we were to agree that SERB is using the wrong articulation of the prima facie case.
Yeah, I don't necessarily agree with that, Your Honor.
Well, I know that. I'm just asking, my question is going to something else, because ultimately we're going to decide that. If we were to decide that SERB used the wrong standard for the first prong of the test, in your view, I'm going to ask you the same question I asked your sister. What is the relief that then we would order. Remand, and remand, and then what?
Your Honor, I have to say, I don't really understand what was wrong with the standard that SERB used.
Okay, but I'm not asking you that. I'm asking you to just assume that we concluded that. Let's just assume that. Do you think it's just then we reverse? Or do you think we would remand?
Your Honor, I don't really know. I mean,
If we remanded?
if you remanded and you said...
Does it go to SERB or does it go back down to...
No, I think you would go to the SERB because the record's already been established. And I think you would be asking the SERB to evaluate the record that was created with a standard that you thought was the correct standard to use.
Okay, I think it would be very useful if anyone has any legal authority on this precise point to submit it in a, if that's okay, in a 16L letter.
I had a case like 40 years ago.
Right.
Where that actually, I used to work at the old Labor Relations Commission, where that actually came up after I argued a case here, and I believe there was a remand.
Okay,
I can
it
try
would
to
be-
find that.
We have an
That'd be great.
unstated principle of trying to be consistent with our previous decisions, so if you have one that
Even
would
if
help give us guidance.
40 years or not?
Yeah.
Yep, okay.
Yeah, that'd be great.
I'm going to conclude the argument unless the panel has any further questions. They don't. Thank you, everybody, for going over their time. There was lots of questions that were important for us to resolve, and we appreciate it. So,
Thank you.
thank you. And of course, sir, any other arguments in your brief are not waived, as you know. Okay. So the court's going to stand in recess for about 10 to 15 minutes. Thank you.